Hey, how's it going, everybody? Welcome back to 2A News Now. And as always here at 2A News Now, you get your Second Amendment news straightforward and to the point with no BS added in. Federal courts uphold limits on guns, but not ammo. Two recent decisions from federal courts on opposite sides of the country illustrate the current widespread legal ambiguity surrounding constitutional limits on gun control. On the West Coast, a court found that a law limiting gun purchasers to only one firearm per month was impermissible under the Constitution in the case Nguyen versus Bonta. Meanwhile, on the East Coast, a federal appeals court ruled in Ocean State Tactical versus Rhode Island that a law banning magazines loaded with more than 10 rounds of ammunition would be allowed. Perhaps no issue in American politics is as omnipresent as the tension between advocates for gun control and supporters of the right to bear arms. Those in support of gun control point to gun violence statistics and high-profile mass shooting incidents. Their opponents simply point to the Second Amendment of the Constitution, which enshrines the principle that the right of the people to keep and bear arms shall not be infringed. Some people say, like most constitutional rights, the right to bear arms is not absolute, and I disagree with that wholeheartedly. Historically, both the federal government and the states have regulated various aspects of gun ownership, including taxes, background checks, and outright bans on certain weapons deemed especially dangerous, like machine guns and sawed-off shotguns. In more recent history, however, the Supreme Court has pushed back against gun regulations in a series of landmark decisions. In D.C. versus Heller and McDonald versus Chicago, the justices invalidated laws that restricted ownership of handguns because they infringed on the individual's Second Amendment right to possess such a weapon for lawful purposes, including that of self-defense. In 2022, the Supreme Court struck down a New York law that restricted the right to carry firearms in public places in New York State Rifle and Pistol Association versus Bruen. And in doing so, the justices changed the analytical framework for evaluating gun control laws. Now, to pass constitutional muster, a gun control law must be consistent with this nation's historical tradition on firearm regulations. The Bruen decision has prompted a flurry of lawsuits challenging the validity of gun laws, as lawmakers seeking to regulate guns continue to test the limits of the Second Amendment. In California, the state government, aiming to reduce firearm trafficking and gun violence, passed a law that limited the number of firearms that an individual can purchase within a certain period. One of the major objectives of the infamous one gun a month law was make it more difficult for people to conduct straw purchases. The law drew an immediate legal challenge from gun retailers, Second Amendment advocates, and others who claimed that the law interfered with their constitutional right to keep and bear arms. In Nguyen versus Bonta, California argued that regulations that limited the quantity of arms otherwise protected by the Second Amendment were consistent with historical regulations limiting gunpowder, and they're just full of shit. The federal court was not convinced. They said they were full of shit as well. Well, not exactly, but that's how I look at it. It found that the purposes of the gunpowder regulations were distinct from the purposes of the California one gun a month law. The historic gunpowder laws were aimed at preventing accidental fires and explosions related to the storage of the explosive substance. On the other hand, California's law sought to prevent criminal acts because the purposes of the laws were different. The court determined that California's law was unconstitutional, finding that the Bruen test requires a more closely matched historical tradition of regulation. In 2022, Rhode Island passed a law that criminalized the possession of any magazine box, drum, tube, belt, feed strip, or other ammunition feeding device which is capable of holding or can readily extend to hold more than 10 rounds of ammunition to be fed continuously and directly therefrom into a semi-automatic firearm. A gun retailer and some pissed off gun owners wasted no time filing a federal lawsuit, Ocean State Tactical versus Rhode Island, arguing that the new law violated the Second Amendment. Their suit sought a preliminary injunction to block the new law from taking effect. And when that motion for injunctive relief was denied, the plaintiffs appealed to the First Circuit Court of Appeals. The appellate court reviewed the evidence and affirmed the reasoning that the lower court had used in denying the injunction. Both courts were convinced that large capacity magazines could be banned because they fit into the category of especially dangerous weapons, looking to data both about mass shootings and incidents of lawful self-defense. Limiting the number of bullets in a magazine was found to be reasonable regulation, consistent with the nation's historical tradition of firearm regulation, and the analysis relied on comparisons with the bans of sawed-off shotguns and machine guns, and even Bowie knives. The data evaluated by the court found that these weapons were popular with criminals, but seldom used for lawful self-defense. The decision and its reasoning could influence legal battles in other states as well. Nearby Connecticut and New York have bans on assault weapons and large-capacity magazines that also have been challenged by gun rights activists who are hoping to prevail at the Second Circuit Court of Appeals. Also, a Delaware assault weapons ban has been challenged to the Third Circuit Court of Appeals. With so many different decisions arising from the application of Bruen, the Supreme Court will likely have to weigh in again on how courts should determine what restrictions are allowed under the seams poised to hear a series of challenges to laws and regulations put forward by the historical tradition test. The justices have already heard oral arguments in United States v. Rami, which could offer the earliest opportunity for more clarity on how courts should apply Bruen to modern gun control measures. A decision in that case is highly anticipated because it could affect the courses of several ongoing lawsuits and appeals. Even more recently, the justices seemed split on whether bump stocks could be banned after the Fifth Circuit Court of Appeals struck down the 2018 regulation that outlawed the devices. A decision on bump stocks would likely offer insight into how the nation's highest court will react to challenges to other firearm new technologies that skirt existing rules like so-called ghost guns. Nobody knows how the SCOTUS justices will ultimately rule on these disputes, or the Bruen rule could be replaced or modified in a new landmark ruling. So far, the nation's highest court has indicated some pliability on what is seen as a firm pro-gun posture. Recently, the Supreme Court allowed Illinois challenged assault weapons ban to remain in effect, pending appeal from the Seventh Circuit, leaving gun control advocates hopeful that Bruen might allow for modern regulations of firearms after all. It's just ridiculous that it's a constant fight and battle to protect our Second Amendment rights. And like I said earlier in the video, I believe our rights are absolute, and nobody can convince me otherwise. Let me know your thoughts in the comments section down below. And as always, I appreciate everybody's support for the channel. You guys are always crushing it by liking, sharing, and subscribing and hitting those post notifications. And I really do appreciate it. And I invite you to come back and watch my next video.